We talk a lot about trust planning, whether it's revocable trust or irrevocable trust. Today, we're going to talk about the 2 secrets to naming your trust, regardless of what kind it is. So let's get into it. All right, so the 2 secrets to naming a trust, whether it's a revocable trust or an irrevocable trust, are it's a really important topic. And the reason for this is because it could save you from administrative headache, or it even has this aspect of asset protection depending on how you name it. So just a quick recap. Most people use a revocable living trust. I'm Stuart Green. If you want to stay up to date on the most relevant topics related to estates and trust planning, subscribe to our channel. They'll also use an irrevocable trust. The idea behind a revocable living trust is that you put assets in that living trust rather than in your individual name. And when you pass away, those assets in the revocable living trust are excluded from having to go through probate. So you fund your revocable living trust during your lifetime with assets. Those assets avoid probate. All right, so keep that in mind. Now, a lot of times people will also fund an irrevocable trust during their lifetime. We'll talk about that and what that means in relation to naming your trust. All right, so let's talk about the first issue. I think the first issue is really privacy, okay? So often a person will not really think through what they're gonna name their trust. Often they'll just leave it to their attorney, and the attorney may have, John and Jane Smith, who are a married couple. They're the client, and he'll just give the revocable trust the name John and Jane Smith Revocable Living Trust. All right, so there's a few things that's wrong with that. Number one, going back to this idea of asset protection, or even privacy. So the thing is that the trust could be buying real estate. It could hold real estate. It could hold a personal residence. It could hold interest in LLCs or other businesses or entities. It could have brokerage accounts, security accounts, etc. Let's just say there's some type of situation where there's a creditor claim against you, or maybe someone's wants to pursue a lawsuit against you. They're trying to figure out who owns an LLC, who owns property, and they know that you have something to do with that property. They know that John and Jane Smith have something to do with that property. So it makes it pretty easy for them to be able to go, even if they don't know that the property or the business is owned by a trust. They can go to the Secretary of State website where they're located, type in John Smith or Jane Smith, and see if any entities result back by that name search. And often they will. Most states, or I say a lot of states, most states allow you to search their Secretary of State website to see who's associated with a limited liability company or other entities that are registered with the state. Some states don't allow for that, such as Wyoming, Nevada, a few others. But anyway, the point is, if you put your name on this trust and it owns certain types of property, you're going to open yourself up to be searched to be associated with this entity. Same thing with real estate, whether it's personal residence or otherwise, real estate, commercial real estate, or maybe it's multifamily rental units or single family rental units or whatever it is. If you own property in the name of that trust, then someone can go to the county clerk deed office and search properties by the name, your name, and anything. If they have a good search function, then it's going to pop back up that there's this John and Jane Smith Revocable Living Trust. So an added element of privacy would be to give that trust a name that has nothing to do with your family. All right, so same idea applies to an irrevocable trust. Often irrevocable trusts don't get funded till someone passes away. Sometimes they get funded during someone's lifetime. Regardless of what the situation is, same principle applies, and it makes sense to give that trust some type of name that isn't associated with the family for privacy purposes, which ultimately is tied into asset protection purposes. Make it as difficult as possible for people to find who owns these assets. Therefore, don't give trust a name that's associated with the family. It can be anything that you want, is kind of the cool creative aspect of trust planning. All right. So the first item I just said, privacy, asset protection, don't get leaked back to the family. The other thing is a more practical administrative issue, and it's more related to a revocable living trust. So like I said a second ago, often the attorney may just put down John and Jane Smith Revocable Family Trust or Revocable Living Trust. So this is what happens with a living trust. Usually, well, there's a few things that could happen. I'll just kind of focus on one particular example. But let's just say John Smith passes away before Jane Smith does. His share of those trust assets are going to go likely into what's called a family trust, or maybe a marital trust. The different attorneys may call it different things, but it's going to go into a separate trust for the benefit of that surviving spouse. Okay. And then the surviving spouse continues to have their own revocable living trust at that point. Now, but the point is you end up with two trusts. And then once the surviving spouse passes away, you usually end up with both of those trusts consolidating for the benefit of children, or maybe it even splinters out into additional trusts. But when the first person dies, that particular trust becomes an irrevocable trust. And then when both people die, that becomes irrevocable as well. And so you keep going down the line, but the point of all of this, if that confused you, is that you started off with a revocable living trust, you're going to end up with an irrevocable trust. But if you name assets, if you title assets in the name of that revocable living trust that has revocable living trust in the name of the trust, you're going to have to later retitle assets. And that can be a huge administrative burden. It can be a ton of hurdles, a lot of hurdles to overcome. You're having to call different financial institutions. You're having to update the name of who owns LLC interests. You're having to call, retitle brokerage accounts, have new deeds created to be able to properly reflect who owns real estate. So is it the end of the world? No, but you can avoid this by being proactive in your planning and thinking through these things. So just to recap, give your trust names that aren't associated with the family for asset protection and privacy purposes. And then lastly, for administrative ease, don't put revocable living trust in the name of your trust.